Thank you for your interest in the 1000 Papercut coaching program. This program is designed specifically to help you fight foreclosure and help you stay in your home for as long as possible. Before we get started, I want to give you some disclaimer. I'm not an attorney. Do not believe a single word I say, and you are to consult a competent legal counsel wherever possible. This is purely for educational and entertainment purposes only, and nothing I say can be construed as legal advice. This is just my opinion. So the objective of this program is to basically prevent mortgage fraud and compel the lender to provide proof of standing to give them the right to foreclose on your home or enforce the note, and to obviously keep you in your home for as long as possible. So there's a lot of talk these days about mortgage fraud, so I want to kind of give you an idea of what type of fraud that we're helping you discover and how to get it enforced and kind of set the framework for this, what we have to offer. So a securitized debt loses its security. That's one of the most important things you have to understand. Over 85% of all loans have been securitized, and fundamentally almost all mortgage foreclosures are done in fraud because they have lost their right to security when they securitized your loan through a RIMIC, which is real estate investment mortgage conduit. Anyway, so the point is, we're going to show you how to discover and prove that they have been committing fraud and they don't have the right to foreclose on your house. A servicer do not have the right to foreclose. That's one of the biggest scam out there. Most of the foreclosure is done by a servicer, and they do not have the right to do so. And we will show you how to prove that. TARP, it's the $1 trillion free money that's been given to all these banks to cover all these bad loans. So we, as taxpayers, have already paid these banks who've used this money to buy other banks, to invest in other things, make more money using our money. So they've been paid for all these loans already. Not only that, when they securitize the note, they get paid up to 10 times the face value of your note. So again, these people have been paid. And get this, when your note gets foreclosed on, when it goes into default, the FDIC also covers up to 80% of that loan. In addition, they get your house to be resold, so they got paid several times, and they get covered by FDIC, and they get your house as well. I mean, man, it's good to be in the banking business, don't you think? So this is what we're going to be talking about, and then show you how to uncover this fraud and how to prove it, and then how to bring it to light through litigation, so that you can bring this to court and stop this fraud. Who can use this product in this process? There's some certain preconditions that you want to be in. First of all, your loan has to have some sort of evidence of movement, and we'll talk about it in a little bit. Also, this program is specific for pre-foreclosure. Now, if your foreclosure is due tomorrow, you have a trustee sale, this program is probably not for you. You might want to read the article about how to stop a foreclosure sale that I've posted on this site. Whether you're in good or bad standing is irrelevant in this program. Even if you're in good standing, you can use this program to compel your lender through a series of discovery letters, to compel them to admit that they are in fact not the true holder of the instrument and not the real party of interest. However, that being said, this program is not for everyone. It's not for the lighthearted. So, evidence of movement, what do I mean by that? What I mean by that is when you close with lender A and lender B or lender C is currently trying to enforce the note or trying to foreclose on the property, that's what I mean. There's movement from the original lender of record to the new party. And I'll show you what I mean by the following examples. Okay, let's say we have a scenario where you close with Bank A, and then Bank A sold the note to Bank B, and then sold it again to Bank C. This type of scenario, or was acquired or something like that. This is a good scenario where you have evidence of movement. Okay, give an example would be, let's say you closed with Stearns Lending, and then Stearns sold it to Bank of America, who then securitized it and sell it to Fannie Mae as an investor. This is a good example of classic evidence of movement. Here's another scenario where this is the majority of the scams that's been committed is by this specific example. You close with, let's say, Bank of America, who's the original lender, but then remember, they closed as the lender, but then they turn around the very next day and securitize them and put it into Wall Street and turn themselves into a servicer silently. So here you are thinking you're making payments to the lender. In fact, they're no longer the lender. In fact, they're just a servicer. And like we said before, a servicer does not have the right to foreclose. They, once a note has been securitized, they forever lost their security. Imagine, if you will, a carrot. Imagine, if you will, a blender. And the blender blends the carrot and makes into carrot juice. Well, that's what is sold on Wall Street. And let me tell you, you cannot make a whole carrot from carrot juice. And the only way you can become a true holder of due course is to hold that carrot, and they can never do it. And this is what the fraud, and this is what we're going to show you in our coaching program. All right, examples of how this scenario would be close with Countrywide. Countrywide went out of business and was acquired by Bank of America. Bank of America became the lender of record, and all of a sudden they became a servicer, and the investor is Fannie Mae. And you see when you get a notice of substitution of trustee, something like New York Mellon's Bank certificate trust number blah blah blah, and that's where you know that your loan has been securitized. So a bad scenario, somebody that should not use this program, is somebody that does not have evidence of movement. Classic example of that would be Wachovia and World Savings loans. Unfortunately, a lot of those loans are held or cannot be proven in court that they have evidence of movement. So if you have this type of situation, this program is not for you. So who should join this program? Let me reiterate. We're going to go through a private administrative process, and then we're going to use that information to litigate against the lender. This is not for the weak-hearted. It's an intensive process, and you're going to go through a lot of trials and tribulations. So if you're not willing to learn, not willing to go fight to the very bitter end, then this program is not for you. You have to take responsibility for your personal education. Part of the program is for you to learn the law. I'm going to show you where to go to get resources, learn how to, the rules of court, all these things. I'm going to show you where to go to get the proper education so that you become, be able to play on a level playing field and what to expect when you get involved in litigation. So as I said, the process is a private administrative process. We go through a series of discovery letters to get admissions from the lender. We create an affidavit, which we then use in our civil action. We file a civil action into court. Once we complete our civil action, we get a judgment. We record that judgment at the county recorder's office, do a quiet title action, essentially. And then once we have that judgment, we notify the credit agencies to clean up your credit records. So that's essentially what you get through the process. What you get is sample documents that I've used to negotiate with my lenders. You also get sample pleadings, and step by step, this is the most important thing about our coaching program. We're not going to unload 20,000 hours of content to you in one go as other programs do. We're going to give you step by step, time sensitive, time drip content so that you only get about 10 minutes a day worth of stuff, so you actually get things done and not get overwhelmed with too much information, get into analysis paralysis. We are a very action-oriented program. Another thing that you get is access to our study buddy network. This stuff is intensive, and it's going to be emotionally draining for you, and having access to a network of other people in the program allows you to contact and connect with other people, share best practices, share resources, share attorneys and everything else, or just somebody to talk to when times are tough. You also get access to our weekly conference call where we collaborate, share ideas, and kind of help each other out. As a bonus, you also get access to this thing called what we call the bankruptcy method, adversary proceeding. Frankly, the vast majority of the wins that we find are in bankruptcy court. So we also have sample pleadings that you could use in bankruptcy. And also, a lot of times when you file bankruptcy, what you get is an automatic stay. And the other side will want to lift the automatic stay. And we'll show you examples of other people's objections that you can take and use for your own purposes to fight those lifts of automatic stay. We'll also show you case law examples, archives that you can use. We also give you sample responses that people have used for motions to dismiss. Understandably, once you file a civil action, the first thing the bank would do would be to file a motion to dismiss. We've got several sample responses that you can use to fight that, because what they're trying to do is to knock you off the court before you even get the chance to play, because these are big time lawyers, and they don't want to get into court with you, because if they get into court, they'll likely lose because they cannot produce the proof, and so they want to knock you off. And we want to show you how to fight that by giving you sample responses for those motions to dismiss. You also get access to our discovery documents, requests for admissions. We basically force them to admit certain wrongdoings, and it makes them very, very uncomfortable, makes them literally squirm. Request for production of documents, motion to compel production of documents. So various different other things as well to make the package a lot more robust for you if you're wanting to get into litigation. Again, these are all just samples that you could use when you join the program. One of the most important things, like I said, is you are not alone. This stuff, you can't even talk to your neighbor, you can't talk to your friend, you can't even talk to anyone. Very few people understand this thing. Whereas when you join our program, you get access to our network where you can actually call somebody up within the program, share ideas, and share, hey, I got this response from the lawyer. Geez, what do I do now? It is really intense. When you get a response from a lawyer, it literally feels like you got kicked in the guts. And, where do you go? Sometimes it's good to have a lawyer, but sometimes we can't afford to talk to a lawyer. Where do you go? Having access to a support network is so important, to have somebody to talk to, somebody to cry with. This is what we're about. We're a network of like-minded individuals out there trying to help each other in this very challenging times. What you don't get is one-on-one consulting, email or otherwise, from me. I am not allowed to give you any legal advice. I cannot review your documents. I can't give you my blessing. I'm here just to basically give you ready-made templates, samples that you can use, but I cannot give you legal advice. Conditions. Before you join this program, you need to join Prepaid Legal. If you're involved in a foreclosure or challenges with your lending situation, or you want to get into litigation, you are in a very legally intensive position, and you need to have somebody at your back that you can call for questions about what your rights are. I can't give you that. That's why you want to join Prepaid Legal. It's only $16 a month, and with that, you can call Prepaid Legal and ask them questions about your situations, about your rights, about litigation, civil procedures that I can't offer you. It's so important that you get proper legal backup, and that's why I recommend getting Prepaid Legal. You have to be responsible for your personal education. I'm here as your coach. I provide you with resources, but I can't do it for you. If you're not willing to take advantage and step up to the plate to learn for yourself, then I can't help you. If you're a member of the Bar Association, work for somebody, an attorney, then you cannot join this program. Buyer beware. Please don't join this program. You need to be prepared and accept all the conditions of this program. Take personal responsibility for learning and do your own research. Don't accept anything I say. And I'm not making any promises, any guarantees, nothing. Okay? Everybody's situation is different. Your case is different than my case and different from my friend's case. Everybody's different. Do your own research. And finally, I understand money's tough. Okay? That's why we have a payment plan for you to make payments on this program that stretches over a longer period of time, so that you can afford it. Once you join the plan on a payment plan, you get access to everything. And finally, this is a limited time window of opportunity. The government, the bankers control the government, and the laws are changing, and you need to be aware of that. The window of opportunity is closing. This thing is going to go away very soon, and if you don't act now, then you may not get the opportunity to act. I hope to see you soon. Take care.